is there anything that we should be doing today, or that we can be doing today as business leaders, that will make it less painful when the change comes in?
I think the things that we can do today are just looking at the future of the business, which I think all businesses do anyway. But in terms of the changes that are coming in, a lot of them relate to obviously HR practices, policies and procedures and employees. The only thing we can really do is try and make sure that we've got a firm plan in place for the future. What is the business's 5-year plan and how do these proposed changes?
Amendments have been made in the House of Commons, they're being voted on in the House of Lords and then have to be re-voted on at the House of Commons.
So the bill's in the House of Lords at the moment. The amendments have been made. So if the amendments are going to be accepted or rejected, it will then have to go back to the Commons for them to pass.
Having all of these policies and procedures in place, it feels like quite a big step.
I think it does, and I think it does put a high degree of pressure on those smaller employers that are wanting to get it right, starting at the outset of their journey, or they're just a smaller sized business. And a lot of those changes will take into account the size of the business. So generally speaking, if we're looking at reasonable steps, it will look at the size, the administrative resources of the company. So hopefully that will provide some reassurance.
This episode is brought to you by Instant Impact. Instant Impact provides transformative talent solutions to small and mid-sized companies that are making between 30 and 500 hires each year. If your recruitment's giving you a headache and you don't know where to start, then give the team at Instant Impact a call or visit www.instant-impact.com for more information.
Hello and welcome to We Need to Talk About HR. I'm your host, Felix Mitchell. Sir Keir Starmer's government is bringing in what they call the biggest shake-up of workers' rights in a generation. Frankly, it's coming at a time when we've all got quite enough on our minds. What does it mean? How should we change? When's it going to come into effect? My guest today is Lucinda Chaplin. Lucinda is a legal director in the employment law team at Shakespeare Martineau, and she spent the best part of a decade helping businesses navigate new and exciting employment regulations, if there is such a thing. Of course there is. So whether you're worried about day one rights, flexible working requests, or just trying to figure out what a genuine occupational requirement actually means, then this is a podcast for you. Lucinda, welcome to the show.
Thank you very much. I'm very pleased to be here.
So, big things going on. Would you does this count as a generational shake-up?
I think it does. I don't think that some of the changes that are included within the bill are necessarily all new. Some of the things have previously been enforced and then seem to be coming back to the forefront. But it is a massive shake-up, a massive change, and a lot of changes for HR professionals and employers to be aware of and keep focused on in terms of it's going to be a staged approach. We've now had the steps paper from the government in terms of when they're hoping each of the different changes will come into place. But strictly speaking, it's going to mean a lot of reviews, a lot of keeping up to date with things. And also the Employment Rights Bill, it's still being amended at the moment. We got new amendments just last week on the 7th of July. So there are still proposed changes. Whether those amendments will be accepted or not is still yet to be seen. So it's quite tricky. Even now, we're speculating. We know kind of some of the general principles, but how they'll actually work in practice is still either to be determined in the bill or often in secondary legislation. So it doesn't mean that we're going to have all of the detail when the bill actually passes, but we should have more detail and we should have a bit of a clearer understanding of what we're likely to see in secondary legislation.
It's a good time to be in employment law.
Absolutely, it's a busy time and I think there's going to be a lot of changes. And also it's a bit of a time, I think it's always the case that employers and HR are looking at how things work in practice and updates and changes and trying to keep familiar with everything. And it is a time when you're just expected to be kind of all over everything. I think one of the lessons is we can try and get ahead as much as we want to, but things are still changing. So even if you made changes, last week based on the current draft of the bill, there could still be further information that comes out or changes made.
I think that's the thing that's freaking quite a lot of people out in that we know there's big changes coming. Yeah. We know it's going to be a pain in the arse to deal with from a sort of HR function, employment law, best practice perspective. Like, is there anything that we should be doing today, or that we can be doing today as business leaders that will make it less painful when the change comes in?
I think the things that we can do today are just looking at the future of the business, which I think all businesses do anyway. But in terms of the changes that are coming in, a lot of them relate to obviously HR practices, policies and procedures and employees. So the only thing we can really do is try and make sure that we've got a firm plan in place for the future. What is the business's 5-year plan, and how do these proposed changes fit into that? How do they affect that, and how do the employees impact that as well? Because the changes are going to come in, so all we can do is have a clear plan for where we're going to as a business, and then make decisions and changes according to that.
Because then it's like fine-tuning, then it's like the actual wording of the amendment or the actual article comes in, probably using the wrong terminology here, and then we can just say, okay, well, this is how this impacts this part of where we're going as an organisation, right?
Yeah, absolutely. And a lot of the changes, it'll be tweaks to current policies. They're not generally completely new principles. They're kind of extending the protection at an earlier stage, or they're reintroducing principles that have kind of come in and gone out again. So people will generally be familiar with the concepts. It's just how they work in practice and making sure that we're aware of those and we're prepared to deal with these issues as they arise, and we know where to go with them, policies, procedures, etc.
Cool. All right. Well, let's buckle in.
Okay.
What's changing?
Well, there's a lot of changes. So what I won't go into today is there's a whole host of changes in terms of trade unions and trade union protections, changes to balloting, etc. If you are working with employees that are from trade unions or that are unionised employees, and that's something that you need to be aware of. It's not something I'm going to go into today because it's complicated and the changes are still changing. So the first change that I was going to talk to you about today is one that's been hitting the headlines quite a lot, and that is day one unfair dismissal rights. So at the moment, the current position is that if an employee's been employed for 2 years, they can bring a claim of unfair dismissal to the employment tribunal. And that means the employer needs a fair reason for dismissal, and they need to have followed a fair process for dismissal. Before 2-year service, an employee can be dismissed without following the fair procedure or citing a fair reason. So what the bill proposes to do is to make unfair dismissal rights a day one right, which means that any employee from the point of employment, importantly, they have added that this doesn't mean employees who have not yet begun working. Mm-hmm. So where there's been a contract and offer accepted and things change and that contract's terminated, the unfair dismissal right doesn't apply there. But where it does apply is from day one.
Can I ask? So obviously it applies from the day that they start with you.
Yeah.
How are things like probation periods?
So this is the area that we have had a bit more understanding on. So what's proposed at the moment is that the government plans to introduce an initial period of employment. So that would be a period of time where you could rely on a fair reason, but you wouldn't have the same requirements of fair process as in a general unfair dismissal claim. So at the moment, the government's suggesting that's a 9-month period, so from the start of employment to month 9, so it would be a reduced period. We're assuming a kind of reduced procedure, but it's still going to put a higher threshold on employers wanting to make those dismissals in the early stages of employment, because you're going to need to be able to evidence somehow that the reason for the dismissal was a fair reason, because there are some claims, automatically unfair dismissal, that can be brought from day one at the moment anyway, but they're where dismissals in relation to a certain reason, so for example whistleblowing, they dismissed the employee because they blew the whistle, or because of trade union membership, and there's a whole host of examples there. So that's one of the big changes that's coming in.
What do you think the likely impact of that is going to be on actual businesses? Are we going to see the rise, for example, of hiring people on a fixed term contract to start with to reduce risk?
Well, I don't think that will actually reduce risk. So even on a fixed term contract, then you're still employing somebody. So technically the end of a fixed term contract is still a dismissal. So it wouldn't actually escape the unfair dismissal new requirements. Where I think it will really impact is on recruitment. First and foremost, there's going to be a high focus on recruitment and getting recruitment right, because clearly the better the quality of people are that are coming into the business, the more suited they are to the job, the more you kind of try to cover off the difficult areas meeting the team, you know, testing out skills and things like that, that will help to be able to hopefully minimise the people that you need to dismiss in that first period of employment. The second part of that is going to be really effectively using your probationary periods in your contract and how are they being managed. We often see it that probationary periods can kind of pass us by, they can kind of slip through the net, and then actually somebody's finished their probationary period without actually having those detailed conversations. And a lot of the focus will be on kind of identifying early issues, addressing those, and hopefully working with the employee to improve or to get to the required standard, rather than looking to dismiss, but knowing that, you know, you're going to have a higher hurdle, there's going to be more HR time, there's going to be more management time, and there's going to be more risk if then you're moving to dismiss somebody at an early stage. More risk than there is at the moment, I suppose.
Yeah, well, being obviously expert at recruitment anyway, I always think that's probably best practice anyway, right? To make sure you're making the right hire. But I guess the cost and the risk of making a wrong hire just becomes more acute, doesn't it?
Yeah, it really does. And that's going to be one of the difficulties. I saw a stat, and I'm not sure that it's still accurate, and it was a little while ago, but it was something along the lines of 9 million more people having rights to bring a claim on their dismissal, because there were there's a fair amount of movement in the employment market generally. So if you think everybody that's currently in the first 2 years of their employment, they can't bring that claim, and then you're suddenly including all of those people in the mix. And employment tribunals generally really busy at the moment. We've got, I believe it was record number of claims last year, and it just seems to be increasing. There is a real backlog. We're seeing claims that are brought and then a final hearing doesn't take place for 2 years. So that's a huge amount of time for the employee and the employer to be stuck in that kind of legal battle with no resolution, and makes it really difficult to manage the claims. So if there's an influx of more claims, how is the tribunal system going to cope with that, and what measures are in place? We've not really got a lot of oversight on that at the moment either.
That's very interesting. Right. Okay, we've done day one rights. Tick.
Yes. I'll move on to the next step that I was going to talk to you about today, which is fire and rehire, which it's been in the press quite a lot recently. There was the P&O Ferries case back in 2022, where there were nearly 800 employees that were dismissed, and then P&O engaged a number of lower paid agency workers to essentially do those roles. There was also the Tesco's case recently, in which Tesco sought to use fire and rehire to remove favourable preferential pay terms, essentially, from a number of workers who had agreed to relocate on the basis of that offer. So essentially what's happening is, for the Employment Rights Bill, then they're looking to put an end to the practice of fire and rehire. We thought it might be a complete ban, but actually what's come out in the legislation at the moment is that they're making it an automatically unfair dismissal, where an employee is dismissed after the employee sought to vary their contract and they've not agreed to that change, and where that would enable the employer to re-employ the same employee on the less favourable terms, or essentially replace them with an agency worker. So the most recent proposed amendment would work to limit the circumstances that it would be automatically unfair dismissal. So that is basically, it would only be an automatically unfair dismissal if it was a restricted variation that the employer was seeking to make, which are proposed to be kind of changes to pay, to pension, to hours of work, to holiday entitlement, or a variation to add a variation clause. So they're trying to think of everything to prevent this fire and rehire principle.
So can I ask, just like on a practical level?
Yeah.
I think one of the interesting things about this business environment we're in right now is that we're seeing a lot of businesses in the way that we do Instant Impact that are changing their operating model. You know, AI is coming in. There's a lot more offshoring than there was historically, and much more flexible workforce. So we're seeing a lot of organisations who are changing the roles and responsibilities of people at different levels in the organisation. If someone were to have if this becomes law, under this law, if let's say you have a director of administration and you make them a director. You say, right, we don't need administration anymore because AI is going to do it. We're going to restructure this role into a director of innovation. Yeah. And the roles and responsibilities are different, and maybe the working pattern's slightly different, and how they're judged and what they're accountable for in the organisation is different. And they say, no, I don't want that job. I want to be a director of administration. What are you allowed to? Like, what can you do?
Well, the first step is always to try and agree the change with the employee.
Of course.
That's always the path of least resistance is to engage with the employee, include them in the discussions and what actually is needed in that role and how that's changing and developing, and try and get their buy-in. Usually fire and rehire is a last resort. It is a very extreme measure. Clearly it's very damaging to employment relationships to take such an aggressive step. And that leads us on to actually one of the exceptions from the fire and rehire being an automatically unfair dismissal, which is in the situation where a business is essentially in a really bad financial position and they can evidence that they've actually had to make that change to enable the business to continue as a going concern. But it is really difficult. It's not often that we will go through those circumstances for... Usually it's a more wide-scale change to the workforce, so it would be a change of the overall terms rather than kind of each individual person changing and making amendments. But yes, it's still not the most straightforward process.
Very interesting.
So I've called this kind of family-related leave, so there's been a whole host of changes to family-related leave, and they're not making huge changes, but they're useful to note and be aware of for employers. So the first change is that the bill is removing the 26-week service requirement for people to be able to take paternity and unpaid parental leave. So at the moment, you need to work with an employer for 26 weeks to be able to take that statutory leave. That's no longer going to be required.
That's just paternity.
That's paternity, and it's unpaid parental leave, which is it's a right that people don't use all that often. So parents will have the right to take up to 18 weeks unpaid leave during basically the time their child is a child up until the age of 18. Often because it's unpaid leave, people don't always utilise that.
I did not know that.
Yes.
There you go.
There you go. So there's a change to that. Another really important change is the change to, so introduced more recently, was the concept of parental bereavement leave. And that's being expanded to cover just bereavement leave. So under the bill, the existing right to parental bereavement leave will be extended. And the most recent round of amendments actually removes the 24-week requirement. So at the moment it was for pregnancy loss after 24 weeks of pregnancy, and that's going to be removed. So that will be for it's being called miscarriage leave. But generally speaking, it'll be all under that bereavement leave heading. And more generally, we're still waiting to see who this applies for in terms of categories of relations or how that's going to be articulated. But there will be a right to a week's leave in the circumstances of other bereavements as well, which isn't currently in place.
Is that paid or unpaid?
It's unpaid. Unpaid at the moment, and that's one of the areas where employers will want to look at what they do currently, because generally speaking, employees will have a stance, or they will have a position they've taken when bereavements have happened to their employees, and how will that interact with the new rights, and whether or not that meets with their current policies.
Very, very interesting. It feels like one of those. That feels like one of those employment laws that companies are going to repackage into a perceived perk.
It may well be, because I think that we've all got compassion, and I think that in those circumstances it's quite unusual for an employer to not allow somebody to take a period of leave at all. Paid or unpaid, I think, is more of a debate, and the length of leave needed is really difficult to kind of put one figure on, because no size fits all. But having that statutory entitlement to take at least a period of leave in the event of bereavement will just give people a bit more protection to be able to have that time as well. The last one I was going to talk about in terms of family related leave is the government the Employment Rights Bill, but looks like it's going to extend the protection for people returning from maternity leave. So at the moment, there are protections for those returning from maternity leave in redundancy circumstances or redundancy situations, but it looks like that's going to be extended further, and that would be protection from dismissal for, I think it's 6 months after the return to work, and that would be for any other reason except in specific circumstances. The specific circumstances are yet to be confirmed, so we don't know what that will look like, but that should give people more protection in those circumstances. And it's only right that I mention at this point that although there's not more rights included in the bill, the government has now launched its consultation into parental leave and pay generally. So that is the start of the consultation. I think it started last week. And that's meant to be a full review of the parental pay and leave systems. That will be things like maternity pay and leave, paternity pay and leave, adoption pay and leave, shared parental leave, which is notoriously very complicated and very difficult to understand in practice, parental bereavement leave, neonatal care leave, and maternity allowance. So there's a fair few things there that the government's looking at as well as the bill. So it's such a big area that although the bill is kind of packaging up a lot of the changes, there's also other initiatives going on as well that are likely to have significant changes to employment and HR practices.
Lots of change. Can I ask, I had heard, and this may be a rumour, or maybe it was in some of the previous drafts, but is there something around right to flexibility as well? Or is that a different thing?
No, so there is. So essentially at the moment then, so last April, the right to flexible working became a day one right. And people will often say the right to flexible working, but I would always clarify that it's the right to request flexible working. So from day one of employment, you have the right to request flexible working. And the way the current regime works is you can make the request, there's a time period within which the employer has to consider that request. There's 8 statutory grounds on which that can be refused. So the way that it works under the bill is that there has to be a reasonableness to the refusal. So it's best practice anyway, and a lot of employers will do it as standard, but they will need to set out which of the 8 statutory reasons they're relying upon, and they will have to explain within the outcome letter or be able to justify why they considered that was a reasonable reason to refuse the flexibility requested. And it is quite a wide area, and it has been changed already with the day one right coming in, and now there's the right to be able to make 2 flexible working requests in a calendar year as well. So it's going to be an interesting area.
Yeah, absolutely. And a hot topic for some somehow remains to be that it's a hot topic. Maybe it will never stop. So all of these changes going through.
Mm-hmm.
I'm going to pretend that I know this off my own back, but you actually told me on the way in. So these amendments have been made in the House of Commons, they're being voted on in the House of Lords, and then have to be re-voted on at the House of Commons.
So the bill's in the House of Lords at the moment, the amendments have been made, so if the amendments are going to be accepted or rejected, it will then have to go back to the Commons for them to pass. And then it will go for royal assent, I believe, and then will become a law. I mean, interestingly, they've named it the Employment Rights Bill, which would indicate that it will be the Employment Rights Act when it comes into force. And we already have an Employment Rights Act from 1996. So there's a purely legal aspect of it. That's a little bit frustrating because we're going to have to really distinguish which Employment Rights Act we're referring to.
They might go for a sort of Marvel, just call it 2.
Maybe.
Revenge of the Employment Law Act. So let's say that gets voted in. What do you think? Autumn?
It won't be I don't think it'll be until autumn now. So there's 4 sitting days listed with the House of Lords before they break for summer, and I think they break on the 24th of July. So it's likely it will sit with them because some of the amendments that have been proposed, some are backed by government and some aren't, so they're less likely to pass if they're not backed by government. And so this is where it becomes very difficult because there's so many changes that are being made that people want to focus on and want to be ahead of the curve on, but actually they're still very much in draft form. But that's where there is some reassurance that does come from the steps paper that the government's released about the timings for implementation. So there's a host of changes that are due to take place pretty quickly after the bill becomes law. But those mainly relate to trade unions and trade union protections and repealing kind of previous legislation. The next tranche of changes will take effect from April 2026. Then there'll be a load more in October 2026, and there'll be some further changes made in 2027, likely the April and the October, because that's generally when changes to employment law take place. But hopefully, for employers that are concerned, you can have a look at that steps paper. You can look at the changes that are most going to affect your business or your workforce, and you can kind of plan a schedule around that potentially. And hopefully by the end of the year, we will have a lot more certainty as to what's happening in the actual bill and have some indications on the secondary legislation.
So it seems to me, like, I always tend towards being overly reductive, but you said right at the beginning, it's going to be very little is like brand new. It's all kind of alterations on the sorts of things that exist already. It feels to me that the kind of work that businesses can do to really get ready, as you say, get your 5-year strategy in place. It feels like you'd be surprised the number of companies that we come across at Instant Impact that before we work with them, they have no standardized way of recruitment. They haven't looked at how to structure an assessment process to make it more likely that someone's going to succeed in the role. They haven't done a lot of workforce planning. That, there's a lot reactive. So it feels like the next 6 to 12 months are the right time to get your fundamentals in place, just standard best practice, so that when the law comes in, you can then say, okay, well, we now know that our probation period needs to conform to these sorts of things. This is our I guess, the bar of evidence that we need to show throughout with that. So let's tweak this there. But if everything comes in and then you're suddenly saying, oh shit, we don't have any of this stuff in place, that's where companies are going to get caught out.
Yeah, I think that's absolutely it. I think it's a time to, and it's easier said than done, I appreciate, in a busy business environment, but to go back to basics, look at your employment contracts. Do you have any flexibility in there? Are you able to make changes to certain clauses if you need to? Look at your policies. There are some policies you may choose not to update at the moment, but to be aware of. Sexual harassment is a really big one. The duty to prevent sexual harassment came in last October, and that's in place, and that's being extended by the Employment Rights Bill. So at the moment, the duty is to take reasonable steps to prevent sexual harassment in the workplace. Under the Employment Rights Bill, then the duty will be to take all reasonable steps, and there'll be prescribed steps set out, I think by the Secretary of State, so not necessarily in the bill, that employers will be expected to follow, and that really increases the bar. But if employers have been on top of things to date, if they've already undertaken a lot of the reviews and implemented a lot of the changes when the duty came in October, it's hopefully more of a top-up exercise than re-looking at everything again. And again, if that's an area where it's passed you by without having been able to take those steps or have a look at what you're doing at the moment, it really is a time to revisit that and just be aware of where those risks are.
It feels to me like potentially there's, as maybe with all compliance, it's going to be putting quite a big burden on smaller businesses. I feel like a lot of very large businesses have a lot of these controls set up already. Does it feel to you like, a lot of 1 to 10 employees, 10 to 50 startup, scale up businesses, like some having all of these policies and procedures in place, it feels like quite a big step.
I think it does, and I think it does put a high degree of pressure on those smaller employers that are wanting to get it right, starting, at the outset of their journey, or they're just a smaller sized business. And a lot of those changes will take into account the size of the business. So generally speaking, if we're looking at reasonable, and in a lot of the guidance, if we're looking at reasonable steps, it will look at the size, the administrative resources of the company. So hopefully that will provide some reassurance. But there's a lot to be aware of and to be kind of making steps in relation to overall for those smaller businesses.
I know there are a bunch of other changes that we didn't get a chance to go into today. But I know Shakespeare Martineau have a newsletter you can sign up for, which I'm going to sign up for after this, so I'm kept the rest of things. But are there any, I mean, for businesses that are looking to go that next level down, what's the sort of quick, also check out these things?
Well, the quick reference guide, I think you need to look at the latest kind of publishings from the government. So look at that steps paper, have an understanding generally of what the changes are that you think are going to affect you, plot those out and understand what those are. And again, reviewing what's already in place. Where are you now? Where do you want to get to? And how will this impact that journey? Because employees are key to every business. You know, you're not going to get to those next steps without your employees, but making sure that you've got the right protections in place, you're aware of your obligations, will hopefully support you in the long term and not expose you to unnecessary risk.
Fantastic, Lucinda. Thank you so much for your time today. It was a really interesting conversation.
Great. Thank you very much.